Okay, the number of people joining us has slowed, so I will crack on. Hopefully anybody else who wants to join will catch up with us. Welcome everyone. I'm Charlotte, Patient Advocacy Manager here at Leukaemia Care. You know me from previous webinars. Today we're going to talk a little bit about employment rights for people with leukemia and other blood cancers. And I'm delighted to be joined by Simon. Simon, do you want to introduce yourself for me?
Yeah, good afternoon, everybody. My name's Simon Allen. I'm a senior advisor at ACAS.
And thank you to you and to the rest of your colleagues at ACAS for supporting today. We will tell you a little bit about who ACAS are as part of the webinar, so stay tuned for that. And I'm also delighted to be joined by my colleague Sophie, who you'll know if you've come to some of our recent webinars. Sophie.
Hello everyone, this is Sophie. I'm the Advocacy Officer at Leukaemia Care.
Thanks, Sophie. So we've got a number of different topics we'd like to cover in this webinar, and we're going to split it up into various sections, but don't worry if you don't get your question in the relevant section, we will be able to come back to it, but there will be certain sections where you might find your question to be most sort of applicable, so feel free to just pop it in whenever, and we may hold on to your question to fit it into a related topic later in the webinar, but we will make sure they all get answered at some point. If you're watching us on our Facebook through our Leukaemia Care channel, you are able to ask questions in the comment section and people will pass them over to us, so we'll be able to address those as well. So without further ado, Simon, do you want to kick off with your first topic for today's discussion?
Yeah, thanks for that, Charlotte. Before I start, I just want to clarify. I'm going to start talking about employment law, but there's one point is worth pointing out, because whilst employment rights exist to ensure fair treatment for everyone, they do depend on what is called your employment status. And that means whether you're classed technically as an employee, a worker, or whether you're classed as self-employed. And they're all sort of different labels, but in reality it depends on the nature of the working relationship, not just the label that's applied to it by the employer. And recently, the reason I'm mentioning this is because there are recent cases where self-employed, I say self-employed, plumbers, taxi drivers have actually taken their status to an employment tribunal and have proved actually that they're more like workers or employees, which means in reality they're entitled to more rights. So just a brief point to point out that there are different types of employment status. Essentially, people classed as employees, which would be your standard full-time, part-time, permanent employee, are entitled to full employment rights. People on more casual contracts are known as workers and are entitled to some, but not all, of the employment rights that employees are entitled to. And there are very few employment rights that self-employed people are entitled to, mainly because they are employee and employer at the same time. Now, I'm not going to advise people on their own specific status, employment status, because really the only person that can decide that is a judge, and you may need legal advice because it's quite complex. But what I will say is, when I talk about discrimination, everyone is protected against discrimination, regardless of your employment status. So, if I can start by talking about disability and the definition of disability. First of all, just to be clear, I use the word disability not as a label or as a judgment, but in terms of how it's defined in UK employment law. And to be clear, anyone with cancer automatically meets the definition of disability under the Equality Act of 2010. Different types of health condition have to be able to demonstrate that they have a significant impact over a long period of time. With cancer, that's not the case. They meet the definition from the point when they get cancer, which is generally the point of diagnosis. And whilst in my experience dealing with employers and employees, most employers treat staff in a sympathetic and supportive way, there are occasions where this doesn't happen. And there's a case called, and I'm not going to mention too many cases too often, but there's a case, it's sort of a landmark case called Lofty versus Hamis from 2018, where someone was dismissed on attendance grounds, and the employer argued that This couldn't be discriminatory because the definition of disability didn't apply because it wasn't cancer, it was precancerous cells. Complex case, but essentially the employer lost and the person with precancerous cells was protected. The point is, and that's indicative for future cases, in terms of employment tribunals, cancer is cancer, and tribunals don't look kindly to employers arguing over what stage of the cancer is at. Once an individual has cancer, they have the protected characteristic of disability, even if they go into remission or are clear of cancer, and irrespective of whether they show symptoms of their illness, they meet that definition of disability, so they are protected. Does that make sense? Any questions about the definition of disability or when that might be relevant?
I haven't seen anyone ask as yet.
Right.
I think it was helpful for you to clarify the case about precancerous, because some of our people are affected by conditions where there are still arguments of whether technically they're cancer in the medical world, but most people would consider them cancer. So I think that's a really useful point. And if someone was experiencing that sort of debate, would that be something that would have to be dealt with via legal advice, or is that something that ACAS can also help with?
Well, ACAS can advise on the definition of disability, because generally speaking, the definition of disability is something that has a significant detrimental impact on daily activities, not work activities, daily life activities like mobility, communication, that kind of thing. And generally it's seen to be long term, which generally has or will it last 12 months or more. When it comes, there are certain prescribed illnesses, conditions, multiple sclerosis, I think is one, HIV, the variety of cancers that don't have to prove this long-term detrimental impact because it's a day one definition. So they shouldn't really be, but if there are, ACAS can give some advice in terms of case law, and we can give advice on the general definition of disability when the condition may be protected, what stage it's at, that kind of thing. We can't say for definite yes you are, no you're not, but we can explain, the law, your rights, and what recent cases have demonstrated, if that makes sense.
Yeah, I think that's really helpful. Thank you.
Right. If I talk about disclosure briefly, in terms of talking to employers, employees, colleagues about a condition, legally, no one has to tell their employer about their health condition. That there is no legal obligation. But if you do tell your employer, they then have a legal duty to support you with reasonable adjustments, which I'll go on to talk about, and they have a legal duty to protect you from discrimination, harassment, and victimization, which I will also talk about. If you don't tell them, there's something called constructive knowledge of a disability, which means that if all the evidence is available, even without saying I am disabled or I am whatever I may be, even without having to sort of state that out loud, if all the evidence suggests that that's the case, then they should still treat you as if you are, so the protections are still in place. So there's something called constructive knowledge of a disability. It's a bit vague, but it's sort of an added protection. What I would say is an employer, if you're going down the constructive knowledge of a disability route, an employer can still make the argument that they didn't know. I didn't know, you didn't tell me, which isn't a foolproof argument, but ultimately that's for the judge to decide. The safest way, and I say safest, but I know disclosure is difficult. I'm not saying that in a sort of a dismissive way, but the safest way of ensuring that your rights are protected is to disclose the health condition, is to tell your employer. Now, in terms of telling colleagues, again, there's no legal requirement, but you may decide it's useful for them to know. And I've seen cases where it is useful because the person can decide what is disclosed to colleagues, how it is disclosed, how they want to be treated, that kind of thing. It can be quite useful. But again, is entirely up to the individual. There's no legal obligation. One thing to point out is that employers can't access your medical information, i.e. speak to your doctor, or make you speak to occupational health without your consent. Having said that, they can and they have to make decisions based on the evidence they have in front of them. So they can make decisions that affect you at work based on the information they have. So the more information they do have, the more informed the decisions can be made, if that makes sense. So it may be in a person's best interest to disclose the health condition and to give consent to relevant medical, and I say relevant medical documents, records being consulted with, accessed, so that the employer can make fully informed decisions that can protect you in the workplace. But again, legally, you don't have to. Any questions on the disclosure element? Because I know it's easier said than done. You know, someone from ACAS saying, oh yes, it's really helpful, but I get that it's a sensitive topic and people will be concerned that if I tell somebody, then it could go against me. But I'll sort of cover that in the discrimination part, if that makes sense.
I was just thinking about what you said about the definition of disability. And please correct me if I'm oversimplifying, but it sounds as if it focuses quite a lot on how it affects you rather than what it is that you've been diagnosed with. Is that a fair summary?
Definitely. There are some things where you'll say, regardless, is the menopause a disability? Forget the label, it's the impact on the individual. So menopause as a label may not be a disability, but things that arise from it, if they meet that long-term detrimental impact on daily life, then it can meet that definition. So it is definitely that. I think that's a good way of putting it.
Great. And I suppose quite a few of our patients live sort of long-term with their condition. Is there a better time? If I know that's quite subjective, but does it matter if they don't disclose at the point of diagnosis, if they choose to disclose later on, perhaps when they're about to start treatment, if that's not immediate? Does it matter when you may choose to disclose?
The earlier you disclose, the earlier the protections, the duty applies, if that makes sense.
Yeah.
And it's one way of being quite clear. I'll speak from my personal experience. I have a disability and I disclose it quite quickly, but that's just my approach. I then know that protections are in place and certain duties are in place very quickly. But I think a definite time to do it is when you need the protection. If you decide to do it very early on, when it's not having an impact, but you do it anyway, that's entirely up to you. But definitely when you want the protections in place, I'd say it makes sense to. But again, I'm not being dismissive in terms of how difficult it can be to disclose.
Yeah. And I suppose going back to my last question, do you have to disclose a diagnosis to have this conversation, or can it be a conversation about symptoms without ever telling your employer what you have medically been diagnosed with, if that makes sense?
It does make sense. There doesn't need to be a label.
Mm-hmm.
Whether the employer might then it could make it difficult in terms of, you know, do we, because from a good practice approach, reasonable adjustments just make sense. You don't need to be disabled to have reasonable adjustments. They just make sense. It's about supporting employers and being a good workplace. But you may have that argument where an employer says, well, I don't have to do this because I don't, you know, it's not a legal requirement. Whereas once you do disclose, you know, the label, and you know that disability applies, then they know the legal duty does apply straight away. Does that make sense? I'm not sure how clear I'm being.
I think what I'm hearing is being as clear as you can be as to the cause of the symptoms may help you, as well as be something that you're not particularly comfortable with.
Yeah, that's far more articulate than I've just tried to put it, but yes, that makes more sense.
I'm usually in your position in these webinars. I'll ramble and then somebody...
Clarity of expectation, put it that way.
Yes.
clarity.
Yeah, that's a good way of putting it. Absolutely. Sophie, I wondered if we could come to you at this point. Obviously, we at Leukaemia Care, we have a lot of knowledge about leukemia and how it affects people, and physically, emotionally, etc. Maybe you could say a little bit about how you might be able to support someone to articulate what they're going through at a time, especially around diagnosis or treatment, where it might be difficult to do so. So you want to say a little bit there?
Yeah, definitely. I think that it's quite overwhelming when you receive a diagnosis, and there is probably a lot of language that you aren't quite so familiar with. So to sort of receive that news and to then have to think about talking to an employer about it and to explain something to them that you don't quite understand yourself, it can be quite hard. So I think that I can sort of put myself in the middle of that and sort of be essentially a type of medical translator, so to get the message across from the patient, like, this is what the diagnosis is, this is how it's probably going to affect them, and to sort of explain to the employer what it means and what it means for the patient. So yeah, that's definitely something that we can do here.
You're on mute, Charlotte.
Oh, you're on mute.
Okay, on mute. Classic.
It wasn't me first.
I think we'll make sure we get your contact details up at the end. But I think it's a really valuable service, is to have someone there to do some of the thinking for you when you're in such a challenging position. I think we've covered most of the questions we've had in so far. Somebody's asked about somebody assume being dismissed for their ability to do the job. I wonder whether that fits in a little bit later, Simon, into some of the things we can touch on later, or would you rather cover that now?
Well, it probably fits into the next part if I talk about discrimination.
Yeah,
and reasonable
absolutely.
adjustments. It probably fits into those, to be fair.
Sure.
If I talk about discrimination, the law protects people with some protected characteristics from all forms of discrimination. Disability is protected characteristic, which is why that clarity in the first place, and that, you know, meeting the definition of a disability can be important in terms of protections. Now, there's a variety of different types of discrimination, and I'll just briefly touch on them, and I'll try and be brief. But there's direct discrimination, which is the most obvious one, where, for instance, I am not willing to employ you because you have a disability, in the same way that I might say, Simon, you're too old, or you're a bloke, whatever it might be. That's the direct link towards between the discrimination. So that's direct discrimination. There's something called associative. I call it discrimination by association because I often trip up when I try and say associative, but that would be where even if the person is not themselves disabled, but they find themselves discriminated against because of their association with someone who is disabled, that's the discrimination. And there are cases known, and it's relevant to carers in particular, this one, because there are cases known where carers of disabled people have suffered because of their care and responsibilities. There's a famous case, Coleman versus Attridge law, which they were a legal firm, so you think they'd know better, but it was a legal secretary who was treated unfairly because she had time off to care for her severely disabled son. And she won the landmark case. So there is protection there for carers who aren't disabled but are suffering because of their association with someone that is. So that is a particularly important one. There's discrimination by perception. So someone might say, I'm not employing you because I think you're disabled, regardless of whether you are or not. And it's irrelevant whether that person is or isn't. It's that I think you are, which is the discriminatory factor. So that is protected as well. And one you see more common is indirect discrimination. And that is where there's a rule or a law or a practice that applies to everyone, but has the indirect effect of discriminating against people with cancer, people with disabilities. It's often unintentional. And an example might be redundancy, where someone looks at attendance record as a selection criteria for redundancy, i.e. you've had too much time off, you'll be selected for redundancy. Now, someone with a high number of absences due to their disability would suffer because of this. But the employer is not saying, I'm going to make disabled people redundant. but that's the unintentional consequence, which is why quite often disability-related absences should be or are treated differently to other absences, if that makes sense. So that's indirect. There's also harassment and victimisation, which are part of the same element of the Equalities Act. Now, harassment is unwanted conduct, and this is a condensed version of the definition, but unwanted conduct that violates your dignity or creates an offensive environment relating to your disability. An example of this might be if you are undergoing treatment that affects your appearance and you are teased in the workplace because of your change in appearance. That's harassment. It's unwanted conduct. It has to link to a protected characteristic, but in this case, that would be the disability. Victimisation is often a word used where someone feels picked on. What it actually means under the Equalities Act is if you complain or raise an issue under the Equalities Act and suffer because of it. So you might be asserting a right under the Equalities Act and you suffer because of it. So if you raise an issue at work to do with your cancer and you find yourself treated badly because of it, that would be victimisation. You're also protected from, particularly around disability, discrimination arising from a disability. So that is, it's not the disability itself, but it's the consequences of or issues that are related to it that you are being discriminated against. For instance, I might need lots of time off to attend medical appointments, and the employer might hold that against me. Now, again, the employer is not saying, I'm going to sack Simon or give him a warning because he's disabled. They're saying they're going to do that because of my time off for medical appointments or somehow treat me unfairly because of that. Now, unless they can show it's a proportionate means of achieving a legitimate aim, in other words, unless they can show there's a fair reason for doing this, that is discrimination arising from a disability. Now, at this point, I was going to go on and talk about reasonable adjustments, but I don't know if there are any questions on discrimination.
I don't think I've seen any pop up thus far. Oh, bear with me 2 seconds. No, nothing specific to this at the moment.
Okay. So if I talk about reasonable adjustments, once you have a disability and the employer knows or has constructed knowledge of that disability, the employer has a legal duty to implement reasonable adjustments to help overcome any substantial disadvantages that the disabled members of staff may face. Now, these are often changes to processes in terms of how work is done. There could be changes to the workplace in terms of access points or quiet areas or something like that, or there could be changes to the equipment that's used to do a job. There isn't a definitive list of reasonable adjustments. There are some that are more often used than others, but as I say, there's no exhaustive list. It does depend on the size of the organisation and the resources available to that organisation, as well as the impact on the individual member of staff, other members of staff and the organisation. Generally speaking, an organisation can't just say it's going to cost us money, so we'd rather not. It's about having a justifiable reason why you cannot put that adjustment in place. And it has to be the right kind of adjustment, not here's the adjustments we use. It has to be the relevant adjustment. So medical appointments, for instance, whilst ordinarily this would be, attending a high number of medical appointments might ordinarily be up to the discretion of the employer in the same way that dental appointments might be. When it comes to disabled staff, an often cited example of a reasonable adjustment is to allow more time off for appointments and treatment. Whether or not it's paid or unpaid, again, would depend upon the feasibility of this for the organisation. So there's not a one size fits all where I can say, this is a reasonable adjustment, because it depends what your employer, who your employer is, how big they are, that kind of thing. Whilst we're on the subject of time on medical appointments, there are an increasing number of companies that have a policy that includes something called disability leave. So they have paid periods for treatment and rehabilitation. That's not a statutory duty, that's not a legal right, but increasingly employers do that. So it's always worth, what I'm talking about are statutory duties, legal obligations. In all the questions that are raised, it's worth checking And again, this feeds into why it's useful to have that discussion with the manager, because there might be stuff that are sort of enhanced benefits, if you want to call them that, rather than the legal minimum, such as disability leave, that might cover absences from work. So it's worth first checking the existing contracts, policies in the workplace to see if there is existing leave that can cover absences, then speak to the manager, then maybe request additional time off as a reasonable adjustment. What I will say is, one of the most common forms of disability discrimination that we quite often come across at ACAS through tribunals and settlements is where reasonable adjustments are necessary. They are identified, but they're not implemented. It's one of the most common forms of disability discrimination. Does anybody want to throw any questions about reasonable adjustments?
Well, someone asked a question just as we moved on from the discrimination part.
On
So
the last
we may
part.
go slightly
Yeah.
back. You
Okay.
mentioned something related to whether or not there is a fair reason for treating someone differently and it not being discrimination. And someone's quite sensibly asked, what is a fair reason?
What would a fair reason be? Around a disability, it's hard to think of many, to be fair. They have to demonstrate that it's necessary. So it's this woolly reason, it's this woolly phrase, what's reasonable, which people rely on a lot of the time in employment law, which drives you up the wall because it is quite vague. But that can cut both ways. So there are things, basically, can they show there's a less discriminatory way of doing it? If there is a less discriminatory way, then it's unfair, it's unreasonable, if that makes sense. An employer would need to show that they've tried to do everything they can to achieve their aim. They have to demonstrate there's a legitimate aim. I need to run my business 7 days a week, for instance. One that you quite often come across is people that can't work Sundays. Dismissing someone or not employing someone for not working Sundays, if that's a choice, then that's unfair. If I have no other discriminatory way of running my business, that may be a proportionate means of achieving a legitimate aim. Does that make sense?
Yeah.
Essentially, work backwards. Is there a less discriminatory way of achieving that aim? And is it a fair aim?
Okay. Moving back to reasonable adjustments, then I guess. So we haven't really covered how you'd request these reasonable adjustments. I don't know whether is there like a legal rules about how you go about like the actual process of this. Obviously, Sophie can talk a bit about how we can support people to do that, but are there rules?
There's not a specific form, a specific process. You need to make it clear what the disadvantage is that you're trying to overcome. Quite often, I think I briefly saw a question that came up about would that fall under capability, because the questions are flashing up on one screen as I'm looking at another screen. So for instance, if there was a capability action taken or performance management action taken or attendance management action taken, quite often that's where you can say, well, actually, I have this condition, that means this, this, and this. We need to consider alternatives. We need to consider, reducing my hours or changing the way the work is done so that I can process it in a better manner. And then an employer needs to make sure, particularly if you're disabled, that again, you've tried to accommodate the disability, you've tried to remove the disadvantage. And by removing the disadvantage, one way of doing that is by making these reasonable adjustments. So I can't dismiss you without exploring adjustments that can keep you in place. Does that make sense?
Yeah.
But there's not a specific form. It quite often comes up in those conversations. I've seen it more often than not come up in those conversations. So it does fall into, I'm not achieving an expected standard. Why not? Well, it's because of my health. That's when the reasonable adjustments conversations more often realistically come into place. Another way of doing it is when you disclose, having that conversation openly then. It's about having an open, constructive dialogue with the employer, which relies on your employer being open and constructive, I suppose.
I think quite a few people link this to flexible working requests, but they're not necessarily one and the same thing, are they?
Ooh, well, I'm almost rubbing my hands because that's almost like a Radio 2 segue into the next stage, to be fair, because it can be, and they quite often are, reasonable adjustments, and it adds more clout if you put in a flexible working request and say it's a reasonable adjustment. Shall I go on to the reasonable adjustment bit, or are the other questions? The flexible working requests, or are there other questions?
We've had quite a few questions about reasonable adjustments, so we'll come back to that then. I wondered if you could just clarify this question about capability route. I'm assuming this person means that without reasonable adjustments, the employer has deemed them to be unable to do the job. Is that correct?
That's how I imagined the question, was that for whatever reason the person's not achieving the expected standard, whether it's performance, ability, attendance. So they're thinking of taking them down a disciplinary route or an attendance management route, a conduct or capability route, which could ultimately mean getting a warning, getting a sanction, could ultimately end in dismissal. Well, if they go down that route and they've not explored reasonable adjustments and you have a disability, it's likely to be discriminatory or unfair dismissal because you've not explored the reasonable adjustment route, which is quite often when it comes up at that point. Also, reasonable adjustments might come up where someone has a return to work interview thinking about it, because, you know, quite often disability absences are treated differently to other absences. So there might be a question in a return to work interview, is this linked to a disability? At which point you can then look at, well, what can we put in place to support this to reduce the number of absences, that kind of thing.
Great. Is it too far to say that this Equality Act protects you completely from performance issues? Say you weren't performing for another reason.
If you're not performing, you're not performing. Having a disability does not mean you cannot be dismissed. What it means is the protections in place ensure that you are dismissed fairly. As in, if you should be dismissed, you may well be dismissed. But what you shouldn't be dismissed is something that's beyond your control, like a disability that puts you at a disadvantage to other people.
So it sounds as if this reasonable adjustment conversation can prevent some of that happening for good employers. I can't prevent it for others, obviously. And I suppose one thing I was thinking now, as soon as we started talking about performance, and I appreciate loads of people questions about reasonable adjustments, we will move on to those, is about whether there's any protection from redundancy or any other sort of measures. I'm thinking we're in a recession, or talking about recession at the moment, and then those sorts of things start to come up. I don't know whether you're able to talk about how it protects you in those situations too.
Well, employers need to be very careful when using selection criteria, for instance, for picking people for redundancy. In the same way that you can't pick someone for redundancy because they're pregnant, you can't choose someone to be made redundant because they're disabled. You have to have fair, measurable criteria. So I might say, everyone in this building is at risk of redundancy. I'm going to select them based on their performance, their attendance, a variety of measurable criteria. Now, as I mentioned earlier, quite often attendance is dealt with differently when it's linked to a disability, in the same way that me not being at work, or not me, obviously, but a person not being at work because they're on maternity leave, if performance is measured for 12 months and that person hasn't been there for 9 months, it puts the person on maternity leave at a disadvantage. If attendance is measured, it puts the person with a disability who has more attendance issues at a disadvantage, so they're discounted. The disability-related absences or disability-related factors would have to be dealt with in a different or separate way, or discounted. Quite often it might be, okay, so because of this factor, instead of measuring you over 12 months, we'll measure you over 24 months to have, you know, to even it out, that kind of thing. So particularly around selection criteria, they have to be careful that they're not discriminatory.
Perfect. Thank you. I think I'm sure that will come up more and more as difficult economic times go Okay, so we've got questions on reasonable adjustments related to what they can ask for and when they can ask for it, which I assume you're going to cover briefly, Simon, before we get into the questions. So do you want to?
Well, you can ask for them at any stage, and you need to be able to, there is no limit as to what you can ask for. Whether or not it's feasible depends on the organisation and how it helps you overcome an identifiable disadvantage, if that makes sense.
Mm-hmm.
So I've dealt with members of staff, well, people applying for jobs who couldn't answer psychometric tests because they were neurodivergent, and they asked for a specific way of applying for a job, a different application process. And rather than being given a different application process, they were given more time. The employer thinks that's our reasonable adjustment, but it wasn't the relevant reasonable adjustment. And if that reasonable adjustment is achievable and then seen as reasonable, then not implementing that would be a failure to implement reasonable adjustments, and as I say, would be discriminatory. Ultimately, only a judge can decide. It's about having that conversation with the employer. The employer shouldn't say no. They need to say, we can't do that because of these reasons.
And again,
and cost is just not a feasible reason. Just saying it's going to cost us £200, that's not a feasible reason. There has to be, if it said it's going to cost £200 and that will close the business, then A, I'd wonder what kind of business it was, but B, that's the kind of reason that is justifiable. If it's good, if, you know, building a lift, for instance, could close a small business, so they could argue it's unreasonable. If it's a massive global multinational corporation, it's not the same impact. I don't know if that answered it.
I think that it does answer, I think, most people's questions. So the people asking whether reducing hours or renegotiate contract to part-time is a reasonable adjustment. I think you said anything can be a reasonable adjustment.
Anything can be. It depends on the situation, depends on the organisation, depends on the impact on the individual.
I think someone has asked about something specific to COVID, and I wondered whether you had, last time we invited you to do a webinar, we were still in the end of the furlough scheme and significant talk about COVID. Do you have any knowledge of legal cases where it sets precedent in the COVID, in people worried about COVID and the risk of COVID at work, or is this something that's still quite difficult?
A lot of the legal cases have been around failure to wear masks, people refusing to have vaccinations, that kind of thing. Mm-hmm. I'm not sure in terms of the health and safety aspect, in terms of refusing to work because of imminent danger, but I was going to come on to that when I mentioned health and safety later on. Yeah,
we can come back to that. I think what I would say on the COVID thing is it's just about having the proving the I can't remember what words you used, Simon, to describe the need for the reasonable adjustment, but if you can show you are at risk through a conversation with your medical community, your doctors, your nurses, etc., then I think it should be considered a reasonable adjustment based on that, from what I understood.
Yes, when it comes to COVID, a lot of conversations now are around ambiguities around long COVID and what it constitutes. But in terms of workplaces, it fits more under health and safety mm-hmm. elements of the Employment Rights Act in terms of the duty of care that employers have. And there were several cases where people were refusing to go to work, and it sort of fits under those kind of categories. Risk assessments, which are again are a little bit like reasonable adjustments in that you've got to make a reasonable assessment of what the risks are and be able to justify not doing certain things.
Yeah, I think that's what I was trying to say. not so well. Great, thank you. And then, well, someone's also quite an interesting question about whether the reasonable adjustment is not about performance, but at making life easier. And I've interpreted this about, feeling less rubbish at the end of the day, because I hear that a lot from patients. They're able to work all day, but then they don't feel like they've got any energy left for anything else. Is that a reasonable situation in which to ask for reasonable adjustments? It's not about performance, it's about making your life easier, as this person describes.
I'm not sure what that means. Are we talking about well-being or?
I think so. I think that's what the person's trying to say is,
I think a common reasonable adjustments or additional breaks for people who have, can demonstrate they have. But again, it may be that you have to evidence this through access to medical records and things like that, occupational health, to demonstrate that your condition impacts on your energy levels. So you may need additional breaks. A common one is additional breaks being built in, flexible working hours around, the organization may have a 30-minute break and a 10-minute break, a 30-minute lunch, 10 minutes in the morning, 10-minute break in the afternoon, but someone with reduced energy levels might have micro breaks, 5 minutes between those, that kind of thing. That's a common one. Because it's difficult for an organization to say, we can't allow this person to have an extra 5 minutes when there may be 20 people in the organization who go outside and have cigarette breaks, for instance.
I think I hope I've interpreted that person's question. Yes, someone's talked about managing fatigue. I think that's a really difficult symptom that our patients talk about a lot, is how some days they feel like they have lots of energy and others they can feel they don't have a lot of energy. Yeah, it's is a particularly challenging symptom. I think that this is about, I suppose, working out what adjustments you need. Is that rather than thinking about I'm trying to work out what I'm trying to say here. I think you need to spend some time working out what would actually help with that fatigue.
I think the starting point is to identify what the disadvantage is, and then gather as much evidence as to what a way of overcoming that would be, rather than starting at that this is the adjustment I need. It doesn't have to be that's the adjustment I need, why can't you do it? It can be this is the problem. Okay, occupational health, we'll ask them. My doctor will ask them. We'll have a conversation with managers and myself to identify what we can do together to overcome the disadvantage, rather than the starting point being the adjustment. Does that make sense?
Yes, and I think that's what I was trying to say. It's you have fatigue, but it's that link between the fatigue and the adjustment is working out how the fatigue stops you from doing the work that you would like to, that others are able to do. I think that's the link here. Yeah. And I hope that helps explain. I think it's a good point, Sophie, maybe to bring you back in again. So we're talking here about someone with fatigue, perhaps having to sit down and do some thinking. Is that something that we at Leukaemia Care can help with, this idea of actually working out what might help and how to get that on paper in a way that the employer will understand?
Yeah, definitely. I think something that we can do is sort of sit down with someone, have that discussion with them, and to sort of, work out what you need as a patient to help you to do your job, and something that would make you feel better about it, essentially. So we could have that conversation, work out what you'd like to be put, what you'd like to see put in place, essentially. And then I could also help with sort of like drafting that up into a letter, because if you're struggling with fatigue, it might be quite difficult to put a letter together for the employer, and sometimes it's nice to have someone else who's quite impartial to do that. So yeah, something that I'm always happy to do, definitely.
Thank you. I think sometimes a simple pros and cons list of different things works wonders, personally. We've mentioned flexible working requests when talking to Simon, and that's something also we can help if you wanted to request the adjustment as a formal flexible working request. We can help with that because there are specific things involved in that. I think that was everything I can see being asked and everything I could think of related to reasonable adjustments.
I was just going to mention
Karen.
Flexible working requests. Should I briefly touch on that?
Yeah, I think that would be helpful, because I think people do muddle the two up and also don't understand how flexible working can help with reasonable adjustments.
A flexible working request can be a reasonable adjustment, but it is also slightly different because it's a statutory right that applies to everyone. When I say everyone, I mean employees, and there is a process. So it applies to anyone who has 26 weeks continuous employment. And legally, and again, check your contracts and your policies and procedures, because they may be more generous than this, but legally you're entitled to put in one flexible working request per 12 months. And essentially you're requesting a more flexible working pattern. So some of those questions around reasonable adjustments and, you know, a micro break's not enough for me to have a work-life balance, it may be that a change of working pattern may be the kind of thing that you need. Now, quite often you're looking at changes to hours, working from home, job share, that kind of thing. What you do need to bear in mind, unless it's otherwise agreed up front, you're agreeing to a permanent change to your contract. So you may be reducing from full-time to part-time. Now, there may be some employers who are willing to look at it as a temporary reasonable adjustment, so not affect your terms and conditions in the wage, but others will just see it as a change in your contract. But there is a process. So you put the request in writing, stating that it's a flexible working request. State what the change is. You also need to state if you've requested one previously and when, because you need to demonstrate that you've not, you know, this isn't your second request in a 12-month period. And this is where it's worth stating that if you are disabled, add to your request that you're requesting this as a reasonable adjustment, because whilst you have a statutory right to apply for a flexible working request, employers don't have to accept the request. And there are a list of about 6 or 7 reasons that they can say no. And they're quite vague, and basically it's if it has an impact on the business, we can say no, and about 6 variations of the same answer. The thing is, if it's a reasonable adjustment, that adds an extra level of scrutiny, I'd say, so that any employer who is going to reject a reasonable adjustment request needs to carefully consider their position, because otherwise they're risking being discriminatory, and that's different to not accepting a flexible working request, if that makes sense. So a flexible working request, you could probably turn around and say, we can't afford to do that, and that's an acceptable reason. Whereas with a reasonable adjustment, that's not a good enough reason, generally speaking, in courts. So it adds a greater level, a little bit more leverage to the work for the flexible working request. Now, employers have 3 months to make a decision. The ACAS Code of Practice on flexible working requests says it's best practice to allow an appeal and to state clearly what the reason is. Now, they're not legal requirements anymore, but they are best practice. So an employer doesn't have to give you an appeal, but it's best practice to do so. And it's reasonable to do so, and it's reasonable to explain which of the reasons, you know, they've refused it on. If you appeal, if you are allowed an appeal and it's rejected, you can complain to a tribunal, but it has to be within 3 months of the decision being notified. So either the original decision or the decision from the appeal, you have 3 months, which you can apply to a tribunal against the statutory reasons for the flexible working request being refused. But as I say, if you add it down as a reasonable adjustment as well as a flexible working request, different ball game altogether.
Great. I think that would help clarify, because I do see people talking about them interchangeably sometimes, which isn't. It sounds
quite often the two
helpful.
are used. Quite often the two are used together.
Yeah. Perfect. Before we move on to health and safety, we are running out of time a little bit. Just wanted to clarify on the applying for a job thing. I think we've touched on it a couple of times throughout what we've been saying, but I wondered whether you could just clarify in terms of when you apply for a job. It sounds as if you're saying reasonable adjustments can also be asked for then and have to be applied in the same way if you disclose a disability.
Yes. One of the reasons why employers can ask if you have a disability in the first place is in case you need a reasonable adjustment for the recruitment process. to make sure you're not disadvantaged during the recruitment process. So yeah, that applies at that stage also. But they're not allowed to ask other types of question about your health to determine whether or not you can have the job, unless it's an intrinsic element of the job, a genuine occupational requirement as part of the job. But that is, not something we would prefer. It has to be an intrinsic part of the job in order to be able to do that, undertake that job.
And what about when it comes to discussing your needs in a job and you're sort of about to sign a contract? You've been offered the job, you haven't yet signed the contract. Is it better to discuss what adjustments you might need before or after that point?
Ooh. Interesting question. That's a judgment call. That's a judgment call. I work for ACAS, so I've not got an opinion on that one, I'm afraid.
That's fine. It's just thinking of, people changing jobs post-diagnosis. That must be quite a challenging one. I think the other group of people we haven't touched on too much so far. We've talked a lot about the employee being the one with the diagnosis. We touched on a bit regarding associative discrimination. Were you planning to cover a bit about parental leave later, or do you want to cover this bit now?
I can talk about parental leave. I was just going to talk about in terms of carers' rights, because there is this thing called carers' leave, which people think is a thing, but it's not yet a thing, because there's a statutory, the potential of carers' leave being put into legislation, but at the minute it's not in legislation, so it doesn't exist yet, and that is a proposed bill of 1 week's carers' leave, but that doesn't exist at the moment because it's still going through the Houses of Parliament. Until that point, a carer can apply for a flexible working request, as we've already talked about. There are certain things that carers may be entitled to. For instance, time off for dependents is quite often quoted. Now, that's a statutory right for employees, and that is a day one right. They don't have to have worked for 2 years, but it's quite limited. The statutory level is unpaid, reasonable time off to deal with emergencies. So although you can request that leave from the minute you start work, there's no limit to the number of occasions on which an employee can take time off for dependents, but reasonable time off is quite vague and generally quite short. So if we use the example of the unfortunate event of a funeral, for instance, it might that time off might include time taken to register a death, make funeral arrangements, attend a funeral, but probably wouldn't, looking at the case laws I've seen in the past, cover the lasting psychological impact of a bereavement, if that makes sense. It'd cover the domestics, the short-term emergency things that have to be dealt with up front, and that can be the problem with time off for dependents. It's short-term and to deal with emergencies. When you come on to bereavements, there's parental bereavement leave, and that again is a statutory right for employees from day one. Now that's up to 2 weeks paid leave, and it can be taken in 1 week blocks or 2 week blocks or 2 1 week blocks, if that makes sense. And they need to be taken within 56 weeks of the death of a child under the age of 18. Now, I think there's a period, I think it's 56 days. If it's 56 days after the death, you have to give a week's notice. But this is paid leave, and it's paid at £156.66 a week, or 90% of your normal earnings, whichever's lower, and that's per week. In terms of other leave for carers, for instance, there is unpaid parental leave, which again is a statutory right for employees, but they need to have worked for 12 months and have parental responsibility for a child below the age of 18. If you tick both those criteria, you can have up to 18 weeks leave per child up to the age of 18, but it's unpaid and it's limited to 4 weeks per year. And it's normally taken in 1 week blocks. But for a disabled child, it can be taken in days, but I think there needs to be evidence of disability related payments, or whether it's PIP or DLA, I think. And you have to give notice. I think it's 21 days notice. Now the employer can postpone that, but they can't postpone it indefinitely. They can postpone it for up to 6 months, but they can't just say, no, you can't have it. But again, I'd look at the policies and procedures, check your contracts, because quite often employers will nowadays have more generous carers leave programs than the statutory minimum, if that makes sense.
So you talked a lot there about parents.
Yes.
It sounds like quite a lot of the statutory stuff is focused on parents of people who are unwell. Is the carers leave bill that's hopefully going to come through looking a little bit more broad than that?
Yes, it's similar to the time off for dependents. I've not seen the details in terms of what constitutes a carer, whether it's a dependent, because a dependent can be a neighbour who depends on me, or whether there needs to be some link to benefits. I doubt it'll be the latter, and it's more likely to be the former. It's likely to be a criteria of what counts as a dependent, and you've just got to prove that they depend on you. So as I say, that can be time off to look after a neighbour that has no relatives. I've seen that in the past. So I think that it'll be cater more for carers as dependents than carers who are parents, or carers who are in receipt of benefit or something like that. But as I say, that's not yet law. A lot of people think it exists at the minute. It's not. We've been waiting for a variety of employment related bills to be put into law for about 3 years now. So
we'll keep an eye on that and update everyone if and when it comes through. Okay, we have 3 minutes left. Simon, could you cover health and safety and then very briefly talk about when people should come to ACAS? And then I'm going to give Sophie the last word, and then we'll wrap up, if that's good.
Okay, so health and safety in 2 minutes. This will be a whistle-stop tour. Employers have a duty to prevent and minimise risk to people at work. They need to act appropriately to prevent risk. They need to act appropriately to minimise risk. Quite often that involves identifying how likely it is that someone could be harmed and how seriously they could be harmed. More often than not, it needs a risk assessment to make sure appropriate adjustments are made. Ultimately, and this is the important bit, Section 44, Section 100 of the Employment Rights Act 1996 means an employee can refuse to attend work if they feel they are in real and imminent danger. If you do refuse to attend work because of that, and you suffer a detriment, i.e. you are treated unfairly or you are dismissed, you can complain to a tribunal. And health and safety unfair dismissal is classed as automatic unfair dismissal, so there's no length of service. You don't have to have worked for 2 years. What you do need to do is show that you had a reasonable belief that there was a real and imminent danger. And that's a difficult one because it's about your belief, not concrete evidence that it existed. It's about your belief. Reasonable, again, that word. What I would say is seek legal advice. There's lots of different precedents of people. It happened a lot during COVID. There's a reasonable belief that going to work will cause me imminent danger. And it was sort of that particular element of the Employment Rights Act was applied a lot then. Does that make sense? What I would say is health and safety executive have far more detailed advice on the health and safety side and risk assessments than ACAS do. Maybe I should be saying ACAS's website is better, but on this aspect, HSE website is better. In terms of ACAS help, I think the easiest thing to do would be to give you the helpline number for ACAS, because what I would say is if you've got an employment related issue, check our website, phone the helpline number 0300 123 1100. You can complain to an employment tribunal, but there are lots of time limits. ACAS staff on the helpline can give you advice in terms of what the time limits are, what the risks are, what your rights are, etc. I could say more, but stop the clock.
Thanks, Simon. I think we've covered the topic people were clearly interested in terms of reasonable adjustments. So all that health and safety stuff, I'm sure that they can come to us if they've got any specific questions. Sophie, wanted to leave you with the last word. If someone was sitting there thinking, I don't know what to do next, what would you say in terms of reaching out for help?
Yeah, I'd definitely say get in touch with ourselves, because we can always point you in the right direction if you're not sure what to do, if you're facing issues with employment. So you can get in touch with us through our helpline and also through WhatsApp, because you'll get straight through to me anyway, and also through the advocacy email as well. So if anyone has listened today and thought that any of this would be helpful, then please do let us know and we'll do our best to help.
Thank you. So hopefully my slides will appear for the end conversation. I suppose I could show them myself actually. Oh, there you go. Thank you. I just want to say thank you, Simon, for all your expertise. You explained a lot of information in an hour, and I think everyone's found it really helpful. So thank you for your time again.
No problem, thank you.
In 2021, and thanks, Sophie, for your time as well, as always. Okay, so this bit covers a little bit more about how you can get more help specifically from us. So we've got a range of information sources, a couple of which I'm going to point out. Next slide, please. One is our other webinars. We're doing our last one of the year on a slightly downbeat topic, but I think it's a really important one at this time of year. If you are feeling a little bit alone since being diagnosed with leukemia, or any stage of your journey with leukemia, we're going to have a chat among several patients with personal experience about how you can support each other, and how also counsellor or professional support can be helpful as well. So I hope you find that useful. That's coming up Thursday at 3:30. Next slide, please. We have a number of toolkits that relates a lot of the statutory rights that Simon has described directly to leukemia that you might find helpful, and you can download those from our website. As you can see, we cover a number of topics there. Next slide, please. Sophie's already mentioned the WhatsApp service and the helpline. I'm going to quickly touch on the advocacy support a little bit more. Next slide, please. So Sophie is our advocacy caseworker. If you have a specific issue and you're not sure who to turn to for further support, or need some help thinking through your problem, that is advocacy. That is what we do. Please do reach out and we will do our best to support you. Just because it's related, I suppose, to employment status, we also have someone with specialist knowledge in finances, benefits, bills and those sorts of things as well, our welfare officer. So do get in touch if you need that sort of support as well. Or instead, a couple of notes on fundraising. If you can support us to do more of our work such as this webinar, please do. One way is to order a collection tin for your local shop or somewhere else. Next slide, please. Or we have a number of sort of virtual versions if you're remembering a loved one or a nurse who's been particularly helpful to you through your diagnosis, or some other point in your journey. You can light up a star in celebration of them, which I think is a really sweet thing to do at this time of year. Next slide, please. And finally, here is our supports helpline and email. We will pass on, Simon, the helpline for ACAS as well as part of the follow-up for the webinar and in our YouTube recording of the video. But thank you again, Simon. Thank you again, Sophie. Have a lovely evening, everyone. Thanks for your time.